Hello guys and welcome to LawPutra's YouTube channel, and today we will discuss about the application of Article 16 and Article 311 of the Indian Constitution. While Article 16 talks about the equality of opportunity in matters of public employment, Article 311 talks about dismissal, removal or reduction in rank of persons employed in civil capacities under the union or a state government. I am Jagannath Kulkarni and I welcome you all to this today's discussion. First, let us see what the article is about. So Article 16 talks about the equality of opportunity, and it says, Clause 1, there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. So what includes under the state carries with this. Now, second clause of this article says that no citizen shall, on grounds only of religion, race, caste, sex, descent, place of birth, residence, or any of them, ineligible for or discriminate against in respect of any employment or appointment under the state. So it prohibits the discrimination on these grounds. But clause 3 says that nothing in this article shall prevent the parliament. So parliament can make any law which can prescribe in regard to class or classes of employment or appointment to an office under the government or any local authority or other authority within a state or union territory. Any requirement as to residence within that state or union territory prior to employment or appointment. So residence can be the ground for reservation under clause 6. So parliament can make law. Again, clause 4 says that nothing in this article shall prevent the state from making any provision for reservation of appointment or post to in favor of any backward class of citizens. Now what is the backward class of citizen is the discretion of that state when it is not adequately represented in the services. So again, equality but with restrictions. Now, the additional clause 4a, it talks about the non-prevention of the state in spite of this article for reservation in matters of promotion with consequential seniority in respect of scheduled caste, scheduled tribes, which in the opinion of the state are not adequately represented. So just to ensure the adequate representation of these classes, the state can make the reservations for promotions. Now clause 4b again, which is additionally added, it talks about that again the state is not prohibited for making any provision for clause for the reservations made under clause 4 or clause 4a, but provided maximum 50% reservation for these clause 4 and clause 4a. So backward classes and again the scheduled caste, scheduled tribes, the total reservation should be 50%. Now clause 5, it talks about this, that nothing in this article shall affect the operation of any law which provides that the incumbent of an office in connection with religious or denominational institution or any member of governing body of it shall be a person professing a particular religion or belonging to a particular denomination. So again, this is the another reasonable restriction. And the clause 6 talks about nothing in this article again shall prevent the state. So state is empowered for making any provision in reservation of economically weaker sections, EWS, citizens other than the classes mentioned in clause 4 in addition to existing reservation, subject to maximum 10% of those posts in each category. So even if the Article 16 talks about the equality of opportunity, it also provides the reasonable restrictions. Now let us talk about the Article 311 and how they are connected. This article talks about the dismissal, removal or reduction in rank of persons employed in civil capacities under the union or any state. Now, clause 1 says that no person who is a member of civil service of the union or an all India service or a civil service of a state or holds a civil post under the union or a state shall be dismissed or removed by an authority which is subordinate to that by which he was appointed. So appointing authority and disciplinary authority are to be segregated. This is the clause 1's repercussion. Now, clause 2 talks about no such person shall be dismissed, removed or reduced in rank except after an inquiry. So the some procedure of that departmental inquiry needs to be followed, but provided that where it is proposed after such inquiry to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry. So evidence is also required to decide the penalty. Now again it says that this clause shall not apply where a person is dismissed, removed or reduced in rank on the ground of conduct which has led to his conviction on a criminal charge. So criminal charge again is an exception to this. Now it can also be said that another exception is where the authority empowered to dismiss or remove to person or to reduce him in rank is satisfied. So again this is the satisfaction, or we can talk about the doctrine of pleasure, doctrine of satisfaction, that for some reason to be recorded by that authority in writing that there is reasonably practical, it is not reasonably practical to hold such inquiry. So this inquiry also can be dispensed with depending on the satisfaction of that authority, disciplinary authority, or where the president or the governor, as the case may be, is satisfied that in the interest of security of the state, it is not expedient to conduct such an inquiry. So for departmental inquiry, again there are the exceptions, relaxations. Clause 3 of this article talks about in respect of, if in respect of any such person as aforesaid, a question arises whether it is reasonably practicable to hold such inquiry as is in clause 2, the decision thereon of the authority empowered to dismiss or remove such a person shall be final. So that authority's discretion has to be final if it is up to his satisfaction. Now let us distinguish between the application of these two articles, Article 16 and Article 311. First and foremost, Article 16 provides for equality of opportunity in matters of public employment, while Article 311 talks about the dismissal, removal or reduction in rank of persons employed in civil capacities under the union or a state. Article 16 is a fundamental right of citizens, while Article 311 is a natural right of civil servants and of course the state also. Article 16 is meant for provision of public employment, while Article 311 is the protection of that public employment, especially the civil post. Now let us discuss about some extraordinary or landmark cases in this. The first and foremost is Indira Sahni versus Union of India. It is the case of citation we can see is All India Reporter, year 1993, Supreme Court case, paragraph 447. It's a landmark case, popularly known as Mandal Commission case. It says Union government's decision to reserve 27% government jobs for backward classes was constitutionally valid, provided socially advanced persons, that is creamy layer among them, gets eliminated. Reservation of seats should be limited to initial appointments rather than promotions. So reservation in promotions, no. Then it overturned Congress government's OM, which was reserved 10% of government jobs for EWS, economically backward classes, among higher classes, and reservation should not exceed 50%. Then certain extraordinary situations which are inherent in this country and its people's great diversity must not be overlooked. Some relaxation may be required, and backward class of citizens can be identified based on caste rather than on economic basis. But caste cannot be sole basis for consideration. So reasonable classification is a must. Let us talk about the another case, which is Shukerman Singh versus State of Punjab, which is related to Article 311, which is in the year 1962. The case said, with the question of is termination of service of a government servant punishment under Article 311, and the court said, Supreme Court, suspension from service of a government servant does not fall within category of dismissal, removal or reduction in rank under Article 311. It also said such suspended government servants cannot seek redressal from courts or tribunals as a constitutional guarantee as provided under Clause 2 of Article 311. Another landmark case we can see is State of Uttar Pradesh and another versus Narayan Singh and another. It is year 1964 case again. It said respondent held office, this Narayan Singh, at Cash Department of State after being appointed to post by treasurer with due consent of collector. He held a civil post in this department and thus qualified as a government servant under Clause 1 of Article 311. He was removed from his post without proper procedure being followed, and so this removal is deemed invalid. Then Tahsildars receive remuneration directly from state and are subject to scrutiny, and power of district officers in case of dismissal, removal, reduction in rank or disciplinary inquiry against charges levied. Also, respondent is protected therefore by Article 311 and cannot be removed without following Article 311 strictly. So, removal but subject to following the procedure under Article 311. The famous case of police officer Sachin was twice suspended before under several charges. This is year 2020, the latest case. He was reinstated to his office in 2020. In the following year, business tycoon Mukesh Ambani received threat letters, followed by bomb blast in his residence Antilia in Mumbai, followed by murder of Mansukh Hiren, who was involved in bombing case. Sachin was suspected to be involved in these cases. He was arrested by NIA, National Investigation Agency, on suspension to be guilty under UAPA, Unlawful Activities Prevention Act 1967 of Maharashtra government. He was subsequently dismissed from service in Mumbai Police by Mumbai Police Commissioner. He was dismissed without any departmental proceedings being held. Police Commissioner dismissed him under provisions of exceptions under subclause B of Clause 2 of Article 311. Police Commissioner gave his reasons in writing as conducting departmental inquiry before dismissing Sachin was not reasonably practicable. He was held in instant case as Sachin remains dismissed, keeping in mind gravity of offences and reasonability of applying the exception. So, person dismissed can seek redressal from a court of law or respective state's administrative tribunal or CAT, that is Central Administrative Tribunal. So, we can conclude with today's discussion that Article 16 provides for equality of opportunity in matters of public employment subject to reservations for weaker sections of society including scheduled castes, scheduled tribes and economically weaker sections. And Article 311 provides for dismissal, removal or reduction in the rank of persons employed in civil capacities under the union or a state, again subject to natural justice and gravity of the case involved. So thank you all for today's discussion where we discussed about the application of Article 16 and Article 311. Thank you. I am Jagannath Kulkarni.